slip itself. But the subsequent pair is also that they have placed me under a suspension without any grounds. So I've already filed it.
I think 25. Well, here this case, the response number 4 has filed everything. And
25 is connected to 24.
24, my lord. My lord, in our case, my lord, the response number 4 has filed everything and took your served yesterday. Day before yesterday.
Have you informed the other counsel?
Well, no, I did not. Other side. 25.
Right, but 20, it is connected to 24. So let both the matters come up again after in the first week of May.
We want to file a reply.
Right. How much time do you want?
At least 10 days.
Mr. A.R. Sikdar, counsel petitioner, counsel to the petitioner appearing in item 25, submits that he would like to file a rejoinder to the affidavit filed with the respondent. So, since 25 is connected to 4, then both these matters will be listed again on 6th of May.
Fine.
With regard to my item number 21 and 27, my lord, in both the matters, my lord, I appear for PTC, but we are seeking some time for obtaining instructions in both the matters, my lord. I have informed the other side. Kindly, these matters may be taken up in the second week of
21 and 27 on the request made by Mrs. Bora, standing counsel PC, standing preferred. Second week of May on a date to be fixed by the registry. Submitted that consent of the petitioner has also been obtained.
Item number 26. Here in this case, no, the respondent PW and Health Department has filed. Here we are going to file a
Item 26 on the request made on behalf of the petitioner, matter stand referred to be listed after has submitted that the petitioner would like to file a rejoinder. The affidavit in opposition filed by the respondent.
By today, also.
The affidavit filed during the course of the day. This after
pay for it.
15th of May.
For the response number 3 and 4. It's Lordship, in the last order, Lordship asks for some record, Lordship. On some record.
Have you informed the petitioner?
Yes, sir.
You have the records?
No, Lordship. What are yet to be
item 33 on the request made on behalf of the counsel for respondent number 3 and 4 stands referred to be listed on 15th May. Submitted that the records call for it. Let it be issued. Issued or not?
Yes.
Yes. So let it be listed in the part 2 list of June. Or part 2, May list. Part 2 list of May. Mentioned it. You mentioned it for upgrading. Take it up. Let it be in the part 2 list for hearing.
Yes.
Part 2 list of in the month of June.
Item number 12.
Item number
12.
12. Item 12. The request made by the council to stand referred after 2 weeks.
Item pertains to service regularization.
15 May.
Value list.
Item 37.
Item
37.
Yes, sir.
Advance domestic assistance.
Huh?
Advance
adjournment slip has been circulated.
Okay, item 37, on the basis of the adjournments circulated, matters can be referred.
But this is
The Borwa heard the B Borwa and it comes. To notice returnable board.
else
Huh?
else something.
Else something. Appears on behalf of respondent 1 and 2. 1, 2, and 3.
1, 2,
The respondent, the representative, extra copies furnished within the period of 1. Respondent may complete their instructions and file necessary affidavit by the next returnable date. Yes, similar, up to 4. Similar orders 1, 2, 3, 4. Appellate.
Minor appeal has been disposed of.
Disposed.
Have to my lord tell that order. I may be allowed to withdraw the liberty.
Reference to the earlier order dated 2026, the learned counsel for the state submits that the appeal preferred by the petitioners to disposed of by order dated 19/3/2026. The appeal filed by the petitioner stands rejected as time barred by order dated 19/3/2026. So, copy of the said order is placed on record. The counsel for the petitioner, the other end, submits that since the appeal preferred by the petitioner stands rejected, you would like to assail the said order passed in the appeal. Therefore, seeks to withdraw the present writ petition with liberty to file afresh. Where made is allowed, writ petition dismissed on withdrawal with liberty. Interim orders, if any, stand vacated. Yes.
Today, things for the instructions to be obtained by the CJC. And at the same time, we have submitted on additional affidavit, as the lordship asked me about the rules and regulations about the transfer as far as SOP is submitted.
There is already an interim order. I heard Mr. I.C. Gogoi, Learned Counsel Petitioner, MS.
N.N. Sharma.
N.N. Sharma, appearing on behalf of Mr. T. Respondents. Ms. Sharma accepts notice on behalf of all respondents. Respondent their instructions and file necessary affidavit. Sixth of May. Interim order passed earlier will continue in the next date of listing. 6th. Instructions, any?
For instruction, some complaints received against the petitioner. That's why Honorable Minister Library Services have passed this down.
Read on record. Heard. Mr. D.K. Das, yes, for one. Government advocate, if you respondents to notice since the learned government advocate submits that she has received some instructions. Let these instructions be brought on record. Matter be listed on 6th of May. 6th of May, by which date the respondent will complete their instructions and file necessary affidavit. The order passed earlier will continue till the next date of listing.
Regarding promotion, of the post of Gauhati helper to the post of Gauhati worker. What has happened, we appointed in the year 2010, and in the meantime, the worker of
You're appointed as what?
an Anganwadi helper.
Anganwadi helper.
Anganwadi helper. So in 24, the worker of the center died. So as a result, I was interested the works relating to the Anganwadi worker of the center. So what has happened, in the meantime, some Anganwadi centers are amalgamated. The Rosin kindly come to page 31.
Page,
So,
page,
Page 31. So this is the dated 15th of June 23, and whereby some of the centers got amalgamated. Our center is page 35. Page 35 is serial number 59. Serial number 59, that is the Madhupur Prohibitions Madrasa, which is a mini center, and it is amalgamated with Morangal ME school. So after that, what happens, as per verbal direction of the authority, I was directed to work in this Madhupur Prohibitions Madrasa, Anganwadi center, without there is any written order. So accordingly, I came to this center since 21/10/2024. And in fact, I was directed to teach my work relating to the alia center of the worker. So till 2026, I was working in that particular center.
till which date?
Till that is 10/2/2026. In fact, this is contrary to the conditions. That is, your lordship will kindly come to
You are working contrary to the conditions.
contrary to the conditions, because Anganwadi helper and worker, from the amalgamated center, they are placed in the service if there is any vacancy arises. So I am placed in a center which is already amalgamated, which that is what I have pointed out at page 33, page 35. That is Prohibitions Madrasa, Madhupur Prohibitions Madrasa, that is already amalgamated with Morangal MB school. So this is your lordship will kindly come to page 31. The condition which is contrary to this point 4, para 31.
Para or page?
Page 31, para 4.
Page 31.
Page 31.
Yes.
So this condition your lordship will see, as in when a vacancy arises in any Anganwadi center within the same ICTS project, the voluntary services of the duly engaged Anganwadi worker helper from the amalgamated centers may be placed with the center having vacancy. So in fact, I have been placed in a center which is already amalgamated. So this is contrary to this the conditions of this amalgamation communication. This is by the joint director to the governor person to the director. So in the meantime, in fact, it is done because to accommodate somebody of their favor. So eventually, one respondent number 5, now she has been absorbed in this alia Anganwadi center as a Anganwadi worker. So because of my
Absorption on, was she appointed through the regular process?
in fact, it's absorption.
Absorption.
Absorption. So this is not permissible.
Yes.
And I just have to go, Lordship, and I have to take instruction.
Meantime, my lord, this communication, my lord, order, my lord, shall not be given effect.
Which order?
This, my lord, 3126.
But
Page number?
Page number, my lord, 44. By this order, she has been, my lord,
this was passed on 3/1/26.
Page
And-
number 40?
44, my lord. Although this is of 3/1/26, my lord, I was permitted to work till, my lord, 10 to 2026. Till then, she did
But
not.
she
my
must have joined by now.
Yes, Lordship.
lord, my lord, she, my lord, for a considerable period, my lord, she did not join. So,
Are you
my-
still working? You're not working there now.
I am.
You're not still rendering. You're not rendering services till now.
No, I am, my lord, rendering service in this, my lord, where I am placed, my lord. That is Prohibitions in Madhupur Prohibitions Center, my lord, Anganwadi Center. And in fact, after this letter is issued, my lord, I was continued to work till 10 to 2026. So this, my lord, suggests that, my lord, in fact, authority did not allow her to join. My lord.
Allow whom?
That is private respondent number 5, who has been now absorbed, my lord, in the alia center, where the worker post was, my lord, lying vacant.
But without instructions, what is the
Yes,
point in giving an interim order? We don't know what is the status, who has joined.
Yes,
You are also not working there.
In fact, my lord, I am working in this, my lord,
You are working in this Madhupur,
Madhupur Prohibitions,
which has been absorbed
absorbed, my lord.
with Madhupur to be a madrasa.
Yes.
And the respondent 5 has been entrusted the work of Anganwadi worker.
Yes. In fact, I have been, my lord, discharging the, my lord, work
You
of
have
work.
been, but as on date, you are not discharging.
Yes.
So how does it benefit you by putting this order in stay?
In fact, my lord, I became eligible to be, my lord, promoted.
That is
So that has
that
been
is something
ignored.
we'll examine it. But with effect from February, you are not rendering any service.
I am rendering, but, my lord, my lord, the post-on data activities was allowed to me, my lord, till 10 to 26. My lord, that is after this letter is issued, my lord, the respondent number 5.
Correct. But after 10 to what happened?
I am still working there, but, my lord, not the capacity of the worker of this earlier center.
Then how, in what capacity are you working?
Now I am working as helper, my lord, again. After, my lord, 24 to 26 for 2 years, my lord. Now, because of she has been absorbed, my lord, I have been, my lord, dropped.
So we'll examine that. Is notice required?
I can take instruction also.
Take instructions, tell us. Third, counsel for parties. Dictionary relief by the improved order dated 126, whereby the private respondents are shown to be absorbed, entrusted with the duty of Anganwadi worker at Madhupur via Madrasa with immediate effect. So, Commissioner was rendering services as Anganwadi helper in Madhupur Madrasa Anganwadi Center under the Paki Moria Integrated Child Development Project, Paki Moria Nogam. Subsequently, the post of Anganwadi worker fell vacant and she was allowed to render services. Said Anganwadi Center. Stop. Thereafter, private respondent is shown to be entrusted with the Anganwadi worker by Anganwadi worker and also indicating that the Prakati Hill Madrasa Anganwadi Center has been merged with Madhupur Madrasa Center, Anganwadi Center, and the private respondent was entrusted with duty of serving. But in this, where are you serving as helper?
My lord, I am working, my lord, in Prohibitions, my lord,
But that is merged.
That is marked with, my lord, some Morangal Abbey School, my lord. That is your possible see. That is that page, my lord. But Prohibitions is not amalgamated with, my lord, Kutubia. Gauhati seal is, my lord, amalgamated with Morangal ME school, my lord. That is at page 35.
According to the petitioner, Gauhati Hill. Via Madrasa Anganwadi Center. Sorry, Gauhati Hill Madrasa Anganwadi Center has been merged with
Morangal ME school,
page number.
page 35. At serial number 59.
Has been merged with. It does not reflect.
That is at page 35, my lord. Yes.
Serial.
Serially, my lord, the serial at page, serial 59, my lord.
59 is Madhupur Pragati Hill Madrasa.
Yes, my lord. Where I am, my lord, working.
Working. So, madrasa and the state council will obtain instruction as to the claims made by the petition. This is the not issue. The extra copy is furnished. When can you furnish?
Please check, my lord.
In the course of the day. Matter be listed again on 27th of April,
Kindly fix it on first week of
first week of May.
And my lord,
On 8th of May.
shall not be given effect. Because, my lord, so for my knowledge, my lord, for considerable period, he did not join.
Sorry. What stay you want?
This later, my lord.
How does it affect you?
Because of how, my lord, I have been deprived of.
That is your final prayer. We'll consider it. We're not rejecting your prayer. 6:8.
Selected for appointment against the post of CRP. What happened in this case is that, my lord, person to an advertisement, my lord, I applied for selection against the post of participated in the selection process. Did the computer-based written examination, physical efficiency, standard test. Thereafter, it was called for document verification. Look, that document, your lordship will find at page 50. This is the call letter for document verification and detailed medical examination. Page 50. Now, participating in that process, he was declared to be medically fit, and his document was also held to be in order, my lord. Only thereafter, the select list was published. Select list, lordship, the relevant portion will find at page 51. The first name is the name of the petition. Thereafter, what happened, my lord? Just 2 days prior to the date of appointment, he receives a call from the CRPF authority saying that the certificate, EW certificate, which he has submitted, is for the financial year 2025-2026, and it should have been for the year 2024-2025. So he was asked to submit it again, my lord. He did so by way of a representation, which is at page 54, and the certificate, lordship will find at page 53, my lord. It's dated 3/2/2026. The validity was corrected, my lord. Thereafter, he again received a call saying that the certificate has to bear the same number and same issue that as the first certificate which he has submitted. He again approached the authorities, the circle officer, my lord, that mistake was rectified, and the final certificate which he obtained from the circle office, lordship will find at page 57, annexure 8. The earlier certificate was cancelled, and this has been issued again, bearing the same issue number. And
Which one?
Page 58. The final 57.
57.
57.
Earlier was cancelled.
Earlier was cancelled. That is page 52, my lord. 52 and 57 bears the same number, issue number, and the date. Initially, this was issued. The validity period was different.
Can it be done like that?
No, the author, it's a certificate, my lord.
Once it is issued, it is issued.
he had applied and earlier was cancelled, my lord. Because
No, you may cancel it, you may issue a fresh one, but
yes,
can you cancel the original certificate and issue another in the same place with the
Modified
same
one.
number?
it has been modified. That is why I have also made the circle officer a party. There is no fraud played by the petition stating this.
No, we are not suggesting you were playing any fraud. We're just trying to understand
the-
that there is a certificate issued. That certificate has a particular unique number. Subsequently, you find that it requires some correction. So, authorities issue another certificate indicating it is a rectified certificate, but can it have the same number?
Well, the
Same
CR
date? Same
CRPF,
date?
CRPF authorities,
No,
they
no, is it the same date?
same date, modified. It's modified. Modified.
How can that?
That is what the CRPF authorities require.
CRPF authority may ask you for the moon,
I understand,
but
my lord.
it doesn't mean that whatever is not within your riches,
But-
you'll find a way to give it to them.
I have applied, my lord. They have issued it. my
Yes,
Not the
CRPF.
lord. They say that
Why are you asking for such unreasonable things?
Instruction will be required.
Of course. We'll keep it for motion.
they may fill up the
Therefore, we wanted to keep it for motion.
one maybe kept.
How many posts are there now?
There are number of posts. They are
then-
appointing in
Yeah.
phases, my lord. All the persons have not been appointed. They are-
Already.
few
process is
persons have been
complete
appointed,
also.
my lord, because
So, keeping
Whether
one post vacant is not necessary. If there are posts available, we will ensure that these posts are there. But give us within 2 weeks, all the posts are not going to be filled up.
I understand, but
We
if
want them
something,
to find out what kind of instructions, what kind of insistence are they making. That's the only thing.
I understand, but if someone is appointed against the post and posts are filled up, my
It's
lord,
not just one post. How many posts are there? Where
total
is the
79,000 something.
then?
But in the CRPF there were my lord, there were 11,299.
Then? So what is the stage of filling up of the posts?
So far, some is concerned, my lord, not all the posts have been filled up, my lord, because the training center doesn't have the capacity to accommodate all of them at the same time. So they are appointing in phases. At this moment, there are vacant posts, but in the meantime, if they fill up, my lord, complications might arise.
The complications will not arise, but we will, yes, what do you say?
Instruction, I will take instruction, well, whether the post are vacant or not, it is not known.
Then we will keep it one post vacant. Heard Mr. B. Sharma, Learned Counsel.
Kindly fix it immediately after vacation.
The MSS for one of the Learned CBC respondent. Petitioner submitted his candidature in response to the advertisement dated 5/9/24 issued by the what commission is this?
Staff selection.
Staff Selection Commission for filling up the posts of Constable GD in CAPF and SSF, Rifleman GD in Assam Rifles, and Sepoy in NCB by way of examination in 2025. Or by way of examination. Stop. Petitioner applied for and was selected, submitted all relevant documents. Name, according to the petitioner, his name appears at serial number 1.
So, my lord, serial number is record number 25701.
His name appears the select list which is published. The select list
Select.
which was published. However, he received an information from the CRPF authorities that the EWS certificate, which was published, submitted by the petitioner, was for the financial year 25-26, and same actually the same that is necessary is for the financial year 24-25. Subsequently, the petitioner submitted another EWS certificate from the authorities concerned by rectifying this for the financial year 24-25, which, however, was not accepted on the ground that certificate, the first certificate is not accepted, and according to the petitioner, the CRP authority insisted the first certificate submitted by the petitioner should be cancelled, and a subsequent certificate must contain the same number and date. Under such circumstances, petitioner resubmitted another certificate issued by the circle officer Romania, bearing same certificate number and date. However, further instructions, no further intimation was forthcoming from the CRP authority. That being the position, petitioner agreed. Let this matter be listed immediately after the opening.
This certificate is of 11/7/25, and here also it cost 6.5. Closing dates would be 14/10/24.
Whatever it may be, get your instructions. The 22nd of April. 22nd April. By which date the respondent, learner CBC, will obtain the required instructions. Be the next day fixed. One post for constable GD in CRPF pertaining to the vacancies available for the staff selection commission examination held in 2025 kept vacant shall not be filled up without legal report. Although notices are not issued, extra copies will be furnished within the course of the day.
Well,
2 extra copies will be required.
2 extra copies, even 3 extra copies. Yes.
Achha.
But the petitioner is discharging his services as a senior inspector of the auditor of cooperative society, Vishwanath Sariali. Lord, then Lord, he was posted there only in the year 2024 October. Now, my Lord, Election Commission of India, my Lord, has issued an instruction which I have annexed, my Lord. Prior to that, my Lordship may kindly come to page 39, my Lord. He has additionally been, my Lord, given the charge of, my Lord, sector officer for the ensuing elections, my Lord, page 39. Viraj Jyoti Borua, Senior Inspector of Cooperative Societies, my Lord. In the top, my Lord, name and mobile number of sector officer. So he was, my Lord, holding, my Lord, the post of sector officer now, my Lord, for this election. Now, my Lord, the page 40 is the instructions issued by the Election Commission of India, my Lord.
Now this page 39
39.
is a part of some
30,
order, is it?
36, my Lord.
36.
36.
36
Office
is the
order
order.
dated 30 January 2026.
So this is for sector officer.
Sector officer, my Lord, and zonal and sector officer. Instructions and guidelines, and page 39 is the list.
No, 39, that's what we are saying. 39 is a
30.
part of the list.
Yes,
You are giving a relevant part,
my Lordship.
not the entire list.
39 is the annexure 1 part of, my Lord, 36 order, my Lord. 30 January 2026. Now, my Lord,
So you are exempted under the Election Commission notification.
I am exempted, my Lord. Why I have been transferred, my Lord? Because page 41 is the, my Lord, paragraph 3, my Lord. Hence, the Commission has decided that no officer connected directly with elections shall be allowed to continue in the present district posting if your
This is your home district.
home district, Vishwanath Chariali. And page 42, Milan, para 7, category of officers not covered under transfer policy.
Yes, election commission. Not covered. Not covered means they are not entitled to be transferred out because of the fact that he is a sector officer, notwithstanding that it is his home district.
Apart from that, my father, my lord, I have a my father is 90 years old, page 45. It's medical prescription, my lord. He is a patient of dementia with multiple geriatric issues and requires help with his day-to-day activities for mobilization.
But can it be a ground for transfer, not being transferred
My lord,
forever
so far as my lord,
during the
technical-
lifetime of your father?
no, my lord, that is not my prayer. Presently, my lord, this is the condition of my family. And
Dementia,
he is bedridden, my lord, and my mother has
that's
filed
what
a
we are saying,
representation.
that there is no cut-off date that is going to be
Yes,
dementic
yes.
and bedridden
That my
for
lord
this
is correct.
particular month.
But that is why I have submitted. But apart from the technical issue, that I am a sector officer, and my father is also my lord, he is bedridden, and my
Is
mother
there is a circular of the government of Assam where from routine transfers you are exempted to a caregiver.
my lord.
You
And
have
that
that
is why,
circular.
my lord, page 50, my lord.
So there is a circular
My
of
lord.
the personal department. Yes, Mr. Bodolo, anything to submit?
Lordship, otherwise the instruction says that he has been transferred because of.
But election commission
Election
says he's
Commission says
exempted.
that.
We can record your submission that you are exempted. Heard. Mr. M.K. Das, Women Council. Hearing response number 6 MFS. Petitioner is presently serving as,
Sector officer, my lord.
No, no,
Page 39.
what is your effective
I am my lord presently senior inspector
senior
of the
inspector
auditor of cooperative
auditor.
society, Vishwanath Chariali.
of the cooperative societies posted in Vishwanath Sarili? Responsible sector officer. Function as a sector officer during the ensuing legislative assembly elections scheduled to be held in Assam from 9th of April. So, in terms of the order dated 30th of January 2026, name of the petitioner is sector officer. Appears in the accompanying statement showing the detailment of zonal and sector officer. So, petitioner is appointed sector officer for 71-Bihali bracket SC bracket close LSC. Submission of the council for the petitioner that by the impugned, where is the transfer order?
Transfer order, my lord, you will find it page 33.
By the impugned transfer order,
Serial number 25.
petitioner, serial number
25, my lord. Type copy is at
25.
That would be formal.
The petitioner was issued transfer orders and being transferred from Vishwanath Charili to the office of DRCS or ARCS?
ARCS,
ARCS in the district of Lakhimpur. This order was passed on 15/3/2026. So, council with the petition submits that he was appointed as a sector officer well prior to the date of the transfer order. As per the application issued by the Election Commission, clause 7(3), exempts sector officers / zonal magistrate involved in election duties are excluded from the purview of the Election Commission guidelines notification dated 9/2/2026. So, Learned Counsel to the Commissioner submits that although not reflected in the transcript, that the same is issued, not reflected, say transfer order is issued, reference to the Election Commission notification dated 9/2/2026. He further submits that his father is suffering from serious health ailment and he is suffering from dementia and is completely bedridden. Stop. Submitted that caregiving, therefore, stage any view of the matter. Considering health condition of parent, including his father. Mr. G. Bordeman, Direct Counsel for the Population Department, submits that the petitioner district is Sonatarini, and therefore, nine transferred out. And for clause 3 of the same notification. Para MSS Kotoki, Learned Standing Council Election Commission of India, on the other end, submits that sector officers are excluded from the transfer policy as specifically mentioned in clause 7 Roman 3. Election notification dated 9. That view of the matter. Let notice issue. Returnable means. Learned Counsel represent since the respondents are represented by the respective learned counsel. So, the course of the day, extra copies. That will be listed again on copy. Even early date, 27th of May, 27th of April. Till the next date, the next returnable date. Transfer order dated issued on 15/3, 26, insofar as the petitioner is concerned, shall not be given effect.
Usually, there in Lordship will find there is the signature of the registrar.
This is a photocopy is available where?
FP. The right side of
1/8.
Yes, sir. The right side is there now. Right side in the right.
There is no 18 here.
That should be the second copy.
Second book. Second copy. Basically. Bring it on record. File your affidavit or whatever is there.
It's a notice directly.
In deference to the earlier order dated so and so. Petitioner, counsel for the petition, produce the original advice slip, the OPD. Respect of the writ petitioner issued by the Fakhruddin Ali Ahmed Medical College Hospital. Let this be brought on record by way of an additional affidavit as in the first court's file, court's record. In the first, the part one, in the court, the part one court record, this document is missing from the area of annexures enclosed. Is this matter again after 2 weeks? You find it and make a mention.
Suspension, the petitioner was placed under suspension on 15/9/25. So within 3 months, my lord, charge sheet was, that's filed. Thereafter, extension on me. Then again, second extension. Now, office memorandum kindly see page 38, the last page.
Yes.
The possible last page, paragraph, my lord. This memorandum was done in pursuance with direction of the Honorable Court. Next, my lord, second paragraph. He therefore directed that all the senior most secretaries of all the departments shall ensure that the memorandum of charges is served on the so and so. We are not on that matter, it was done. Next, 3-4 lines, my lord. If the charge sheet is not served on so and so, if the memorandum of charges is served within 3 months, a reasoned order must be passed for the extension of the suspension wherever necessary. Then you know, then next, after issuance of memorandum of charge, see, the senior most secretary shall undertake a review within 6 months as regards the desirability to further continue with suspension order. In our case, madam, there is no reasoned order. Secondly, 6 months already over. Nothing has been done till today. So this is now kindly see, my dog, your loss is the first suspension order, page 25. First. Page 24. There was what is the first initial suspension order 15/7/15/9/25. Now you also come to page 35, first extension.
Yes.
Whereas so and so, whereas department proceeding was thrown up against so and so, whereas the considering the grave nature of the charges against so and so decided to stay maybe in the interest of justice. Now further, the government will extend to suspension. The reason order. Simply saying that it is
The reasons are there, but whether these
it is
reasons
not a reasoned order, man.
No,
That's why I'm saying.
it is a reasoned order.
It is an order. It is a simple order,
No,
man.
no. Reasoned order means it must contain the reasons. Now, whether the reasons are sufficient or not is a different issue.
That is why I'm saying, madam, because for extension, my lord, but it is next year also same thing. Next second extension, copy paste, my lord, page 37. Same, my lord, same language.
Yeah, but you can't say prima facie that it is not a reasoned order. Reasons are there, but whether these reasons are
that you also should see, my lord.
whether the
Now-
reasons are germane or not.
So this is one thing. Second, within 6 months, you was kindly see, my lord, that page 38. This memorandum was issued in terms of the High Court's order. So code was issued on 15.
So we'll have to issue notice here to get instruction. What else? What is your prayer to be?
No, my prayer is, madam, I am for reinstatement, madam. Because whether, madam, the further continuation of suspension.
Suspension is not a punishment.
Exactly, madam. But he
You are
should not be allowed to remain without doing anything.
you are-
He is to
you
get
are-
substantial allowance also, madam.
you are getting your subsistence allowance.
That I am not on that, madam. I am on that whether, madam, whether মানে period of further suspension.
That we'll have to examine it by calling.
That's a short date, but that's the beginning instruction, right?
Right.
Notice maybe issued.
Mr. Richard Chaudhary, the council assisted by A.H. Markhan Chaudhary and M.S. Barua, appearing for all the respondents. Also, petitioner is aggrieved by the suspension order, by the continuation of the suspension order, without giving justiciable reasons as to why the petitioner is required to be kept under suspension. So, departmental proceedings have been initiated, but the same have also not been concluded. DP has been initiated, not concluded. So,
6 months already over.
is submitted by the learned senior counsel referring to the poem dated 4th of February 2020 that extension of suspension in 3 months must be on the basis of the reason law. And apart, the use or continuation of suspension are required to be undertaken in 6 months by the senior most secretary of the department. So, submitted that this particular office memorandum was issued by the government of Assam, deference to the direction contained in the order dated 30/11/2017, passed in WPC 6465 of 2007. Submitted that the present extension of the petitioner's suspension is in complete violation of the procedure prescribed under the UM dated so and so. Well, considering the submission made, respondents are represented by the learned state council. When do you want it? Perhaps not in the week beginning from 4th.
Maybe
After that. 13th of May.
coming time, my lord.
The pendency of the writ petition shall not be a bar for the respondents to conclude the departmental proceeding and also pass appropriate orders reinstating the petition if the department desires to. Yes.
Lordship, I have received instruction from my lord.
What instructions?
Lordship, I take about the relevant person, Mayor Lee. 79.
Yes.
Lordship, he submitted that the posting was only attachment, not transfer. The petitioner was required to perform duty in both locations as per administrative need. Such arrangements are routine administrative practice in enforcement work. It is further submitted that enforcement inspector duties are field-based and immobile in nature. The presence of a permanent DTO office building is not mandatory for performing enforcement duties. Next page, my lord. Enforcement activities such as checking, inspection, challan, and enforcement drives are conducted within district jurisdiction. Therefore, the contention of the petitioner regarding absence of the office establishment is misleading and factually incorrect.
Is there an office or no?
Yes, there is office.
There is, but you've not stated here.
There is office before last on 28th of February. I have.
No, but in these instructions, you've stated everything, but you did not say that there is an office.
Lordship, there is an office. I have another letter to produce, my lord. But it's the conduct of the petitioner. It's written by the DTO West Karbi Angla to the
Now,
Commissioner of Transport.
you're not proceeding departmentally against the petitioner.
Lordship, we are issuing so cause.
Huh?
We have already issued so cause.
Show cause.
Yes, my
All
lord.
right,
Lordship,
we will respond to it, but right now, we want to know that you are He's transferred to West Karbi Anglong.
Not transferred, attachment,
Attachment.
attachment.
So
His
what-
original
But
place
he's had to draw his salary from
from
Dhubri.
Dhubri, because his original place of posting is Dhubri.
Hmm.
You'll have to work on attachment basis in the West Karbi Anglong also.
So how does a man who is not required to sit in an office
Lordship,
perform his duties on attachment in a remote district and draw his salary from his original place of posting, which is several hundred kilometers away?
Lordship, there is a office, Lordship. I have shown the photograph. Lordship,
No, we are trying to understand the nature of his duties. How will he perform?
Inspector, Lordship.
All right, he's an enforcement inspector required to perform where? In West Karbi Anglong?
His field duties.
Where? In which district?
Right now, he will have to work in the West Karbi Anglong, Lordship.
Then
Hamlet,
why are you attaching him? Why are you asking him to draw salary from Dhubri?
because his original place of posting
Why
is
don't you
Dhubri.
transfer him to West Karbi Anglong if his services are required there?
Yes, Lordship may direct that much, but Lordship,
We can't direct. Why should we direct?
Lordship, we will do, my lord.
Ah.
But Lordship, what is the conduct of the petitioner, my
No,
lord? may kindly-
conduct will go, but you explain your conduct, your
Yes.
officer, ask him to draw salary from one district, ask him to work in another remote district. What is the reason?
Lordship,
These elaborate instructions don't give any reason.
Lordship, because the petitioner was the original place of posting is Dhubri.
Very well, allow him to work in Dhubri.
No, Lordship,
If you want to send him to West Karbi Anglong, send him to West Karbi Anglong. The purpose of attachment is what? He is not to work in Dhubri, he is to work in West Karbi Anglong.
Lordship.
But
Yes, sir.
you are not transferring him, therefore he has to come back every month to get his salary.
No need to come, Lordship. It's online everywhere, Lordship.
Everywhere,
Nowadays,
but what
it
is
is
the
going
reason?
to the treasury.
What is the reason for attachment?
That
Is it because there is a shortage of manpower and
Yes,
his
Lordship.
expertise are required?
Yes, my
What
lord.
is that?
Yes,
is
my
that
lord.
reason?
The letter, Lordship, the DTO has written to the Commissioner of Transport. My lord may kindly have a look.
Now you tell me one thing. You say his original place of posting is in Dhubri.
Dhubri.
He is not required to perform anything there.
If required, if there is accident incident, he will have to perform there
How will he
also.
perform in two different places?
Because the
Why should he? For the same set of salary.
Lordship,
Are you giving him any additional emoluments? Nothing.
Lordship may
He is a
kindly.
government employee.
Yes, my lord.
Then why are you asking him to perform in Dhubri and also in West Karbi Anglong?
For the corrigendum, to specify, Lordship, the corrigendum, the last page of the petition,
Huh.
department may issue the corrigendum. He is asked to work in the West Karbi Anglong only. The corrigendum.
So transfer him there.
That
Why
will
are you
do,
attaching
my lord.
him to West Karbi Anglong? What is the earthly reason for attaching him to West Karbi Anglong? When you say his services are required in West Karbi Anglong.
Lordship, that will do. But Lordship may kindly observe, but Lordship may kindly have a
No,
look.
we are not observing. We are asking him what is the reason.
Reason
Normally,
because-
attachment can be for various reasons. But it appears prima facie to the court that you are trying to harass the petitioner
No,
or without
Lordship.
any reason.
Lordship, the attachment order is Lordship is filed in page number 24. That
I
date,
can
Lordship.
understand that he's posted in a nearby district and is given an attachment to another nearby district. West Karbi Anglong and Dhubri are not nearby districts.
Lordship,
Then-
the attachment order is dated 2nd of February 2026. As per the photograph received yesterday, Lordship, the DTO office was inaugurated on 28th of February, Lordship. 28th of February 2026, Lordship. And after that,
We are not on the office being there or not there. We are not on that. You want to work him under a tree, make arrangements. According to you, he's required to do field work. So, give him whatever arrangement. We are not on that. We are only asking you that here is the man who have transferred. You have not transferred him.
attachment.
You have attached him. What is the earthly reason for doing it? And that too in a faraway district.
Because there is no enforcement inspector right now,
Then
Lordship.
transfer him there.
That
Who's
will,
stopping you?
that will do, Lordship, because he has filed the case on 2nd of April, Lordship. On 12th of March, Lordship may kindly have a look the letter written by the DTO West Karbi Anglong to the Commissioner of Transport. My lord, may I read, my lord? Lordship, I have given the copy.
Where is the order dated 26?
Page 24, my lord.
20?
24 and except 5.
24.
24. 6th paragraph, my lord.
That order number ending with 170.
This is such a, how is it possible to perform the function? You look at your order, he is attached to West Karbi Anglo.
Yes.
In addition to his normal duties.
That has been rectified by the corrigendum dated last page of corrigendum 14/3/2026. It has been rectified, my lord. And he has to work on the West Karbi Anglong.
But he is not transferred there.
He has been attached to the West Karbi Anglong. We will transfer if required, lordship.
We don't know. We are not asking you to transfer or not transfer. This corrigendum
Yes.
appears to be an afterthought to tell him that no, you don't have to come to Dhubri. You work in West Karbi Anglong. On what capacity?
This is pursuant to my
What
representation
capacity?
I filed my.
As a enforcement inspector,
He's not transferred there.
but his service was attached, my
So
lord.
if it is attached,
No.
he has to report, he has to relate to a particular place of posting. Where is his posting?
Yes, West Karbi Anglong, Hamrin, my lord.
How can it be? You are attaching him only, not
Yes,
transferring him.
That we will do that official.
So we are not asking you what you will do. We are asking you on the issue, on the whatever you have done, you explain your conduct. What is the purpose? What is the purpose of passing an order and giving a corrigendum? You are issuing an order saying that in addition to his normal duties, he is attached in West Karbi Anglong. Right?
Yes.
Then you issue a corrigendum saying the normal duty is not necessary. You stay in West Karbi Anglong. But he is not transferred there. He is attached, which means his parent posting is somewhere else.
The district of Dhubri.
Then what is he supposed to do there if he is not required to be stationed in Dhubri?
So simply as attachment is given to the West Karbi Anglong, Hamrin.
You show me under the rules, under what provision you are giving attachment orders. Show us. Show us on the what, from where do you trace your powers for attachment orders?
Public interest, lordship.
Public interest does not mean you will do anything and everything as per your understanding. Public interest means things will have to be transparent.
There is no enforcement inspector right now, lordship. Only
Then
the
you transfer
petitioner.
him. Who's stopping
Then they
you?
will
You
do,
why
lordship.
instead of issuing this corrigendum is issued to give a picture to the court that he is not required in Dhubri. Forgetting all the while that you are issuing not a transfer order or a posting order, you are issuing an attachment order. Once he is attached, he still has to have his lien over a place of posting, which is Dhubri. Now you are keeping him in Dhubri, telling him no services are required in Dhubri, go to West Karbi Anglong. If this is not harassment, what is? This is arbitrariness of the highest order.
Lordship, this order was issued on 2nd of February, lordship.
We are interfering with just now. This is of the highest order. What kind of, who's issued this order? Commissioner and secretary.
Lordship, the letter, lordship, may kindly have a look. Written by the DTO. After that, lordship may.
Which letter?
Lordship, I have. For this one letter. Yes, may I read, my lord? It is written by the District Transport Officer West Karbi Anglong on 12th of March 2026 to the Commissioner of Transport Parivahan Bhavan. Regarding
So is the DTO powerless to take action against him? Is this how you take action against an errant officer? You have full powers.
Lordship,
Let him report this condition to the election commission. Why has he not done it? Why has the DTO not reported it?
Lordship, that is also, I don't have whether he or she has reported the election commission or not.
But why are you complaining? Why are you showing this internal letter to us? If the Commissioner of Transport is aware that he is not performing his duties, he has within his powers to take every action.
Yes, we have issued focus on this.
You have, do it. But in respect of these attachment orders, what have you done? You are placing a person in one post.
But
You
there is-
understand that a man is appointed and posted in a particular place for the simple reason that he has to draw a salary in respect of the work he's supposed to do. So he's posted in place X. You may give him additional responsibilities, but his salary will be relatable to his parent place of posting. By the
That's
corrigendum, you are saying that no work is required to be done in your parent place. You go that place, but you are not transferring it. What kind of an administration order is stating? High-handedness is this. You are raising a complaint that he is not attending this. What is this? Performing his duties, not attending the various sessions. Take action. Who's stopping you? But not like this. Not like this.
Lordship, attachment order does not prejudice the
You may
petitioner.
give your explanations. We are not accepting your explanations. Prima facie.
because earlier also.
We would have accepted your explanation had this corrigendum not been issued. This corrigendum is nothing but to say that you are not, will not transfer you, but will attach you, so that you have to keep coming to Dhubri, because this is your parent place of posting.
Oh.
What kind of work? What kind of order is this?
The corrigendum was issued because the initial order, the 2nd of February order, the additional workers.
You are giving him an attachment.
Yes,
What
madam.
is the meaning of attachment?
Temporary deployment.
Temporary. Does it absolve you to do your regular duties? Yes or no?
In Dhubri, no, Lord.
No. Why? Then how is it temporary
Because there
duty?
is some other officer also, but in the West Gautier, there is no officer.
We have given you enough indications. Third comes in for parties.
The Lordship may kindly direct to
Notice.
transfer the petition.
Returnable weeks. Petitioner is transferred from. Where is that order?
Transfer order is page number 24.
Just transfer order, attachment order.
Attachment order.
Petitioner is aggrieved by the fact that it was transferred earlier. Page number 19 is.
The promotional transfer, my lord.
That is the
Was
first
promotional.
transfer order, my lord, that is number 19. That was on, my lord, 19/6/2025. Thereby I was transferred from Gwalpara to Dhubri.
What-
Promotion.
What is that order?
My lord, I was promoted as enforcement inspector and then transferred to Dhubri from Gwalpara. Relevant portion is page 16.
Page number.
Page 16, my lord.
16.
Petitioner was initially appointed. You were appointed as what?
I was working as senior assistant,
Senior assistant.
Therefore-
Subsequently, he was promoted
enforcement inspector.
enforcement inspector and posted in Hailakandi,
No, my lord. Posted at Dhubri,
Dhubri.
transferring from Gwalpara.
Subsequently, petitioner was again transferred
On 13/12/2025,
on 13/12/25
transferred on attachment, my lord, that is.
on
And I was
attachment as enforcement officer in the office of DTO Secretary Kokrajhar.
Therefrom, this impugned order, 2nd of February, from Kokrajhar to Kargil.
Again, by the impugned order dated 26, the petitioner was transferred, was attached. The earlier attachment order was withdrawn and the petitioner was attached as enforcement officer in the office of the district transport officer, West Karbi Anglong. Stop. The petitioner was accordingly of the office. It's concerned case of attachment. So the file representations, however, same.
Filed on
Request
6th to represent this corrigendum order. I went to join at Karbi Anglong on 11th of February, and I had to submit my joining report to the Deputy District Commissioner office. It is the page number 20.
Upon the petitioner in the order dated 2/2/2026, some other officers also may kindly have the order. Other officers also attached with some other offices, other districts. Not only the petitioner. There is no malafide intention, my lord. So other officers also. There is no enforcement inspector right now in the West Gautier. If nursing is interfering this order, it will hamper the.
transfer him. We are not stopping you from transferring him, posting him there, post him.
My lord.
Who's stopping you?
Lordship.
But these kind of orders are not issued.
Lordship may kindly observe, my lord.
You will not observe. Why should we observe?
Liberty may be given to us.
You hand over the administration to us, we'll run from here if you want.
And
If everything we have to say, whether you can transfer, whether you cannot transfer, what kind of orders you to hand it over to the high courts. We'll
because
handle
your pendency of a petition, they don't want to do anything. Now, so may dispose of this matter then.
The petitioner was subsequently subsequent to the order, attachment petitioner went and joined in his duties. Stop. It is the further submission of the petition that there is no office available in West in West Karbi Anglong, whereby it has hampered in performance of the duties. Stop. Subsequently, by corrigendum dated 14/3/2026, the corrigendum clarified that in the original order dated 2/26, the petitioner was attached as enforcement officer and enforcement inspector in the office of DTO. In addition to his normal duties in the office of the district transport officer, which has been modified as within quotes and italics, he shall draw his salary from the office of the DTO secretary, RTA, instead of as earlier notified within quotes, in addition to his normal duties as enforcement inspector in the office of the DTO secretary, RTA, to be quotes closed. Considering the submissions made by the petitioner on 7/4/2026, the standing council was permitted to complete the instructions. Today, when the matter is called up, the standing council in her instructions and submits that the petitioner was required to perform duties in both locations as per administrative fee. And the posting was only on an attachment, not a transfer. And that the duties of the enforcement inspector are field-based and mobile in nature, and therefore the presence of a permanent DTO office building is not mandatory. That apart, she has produced a copy of a communication received submitted by the DTO West Karbi Anglong to the Commissioner of Transport, whereby complaints have been raised with respect of the petitioner regarding his performance of duties. Considering the submissions made and upon perusal of the instructions, court is of the view that the manner in which the petitioner has been posted in West Karbi Anglong does not appear to the court prima facie not supported by petitioner after being posted in the district of Dhubri as enforcement inspector in the office of the DTO, attached as an enforcement inspector in the district of West Karbi Anglong by the review order dated 6. West Karbi Anglong are not nearby districts. In case of an attachment, an officer is to made available in its place of posting where he is attached. However, his parent place of posting made the district where he was earlier posted, which is Dhubri, the facts of the present case. So, therefore, for all practical purposes, while the petitioner is posted in Dhubri, is required to perform his duties as an enforcement inspector in the district of West Karbi Anglong. So, reasons furnished before the court on the basis of instructions received, not appeal to court. It does not appear court that there is any reasons germane for attaching an officer in a faraway district away from his parent place of posting. So there is no explanation as to why no specific transfer orders have been issued. In respect of the writ petition, if services are so required in the district of West Karbi Angle. This original order again subsequently came to be modified by the corrigendum issued
14.3.
14/3/2026, whereby the parent order in the original order of 26, whereby the petitioner was attached, it was specified. It was stated that he is required to be attached in the district of in the office of the DTU and Secretary RTA in West Karbi Anglong district, in addition to his normal duty as enforcement inspector in the district of Bukit. So this to modify, and to the extent that he will draw his salary from the district of Bukit. So further reasons have been cited as to why the petitioner, although posted in Bukit, now required to work an attachment in West Karbi Anglong, which is a district several hundred kilometers away. Stop. If his services are genuinely required, then it is open to the authorities to issue specific transfer orders. So this observation of the court is not to be accepted as a direction that the transfer orders are to be issued. So, however, on the reasons furnished, this court is not convinced that the order of attachment is issued in public interest. Accordingly, death notice issued returnable 3 weeks. Since the state is represented by the respondents, there is a way that extra copies be furnished within a period of 1 week from today. The next returnable date, the impugned order of attachment dated 2026, read with the corrigendum dated 14/3/2026, shall remain stayed. So far as the writ petitioner is concerned, is this matter again on 11th. Before that, tell us a date.
As per my lord confirm. First week.
Huh?
First week.
6th of May.
Not sure. Also,
Sixth of-
pendency may not be a bar to
We're not saying anything.
DP of that.
MS has Borba appeals for response.
Let's say respondent 4 is BPC. I am attending 1, 2, 3, and 5.
1, 2, 3, and 5. MSB Bora for BTC as Borba for district of.
Transfer order.
Only in respect of the writ petition.
Yes.
Let's made it clear. Please serve extra copies by today if possible.
Obliged. इसमें गाली की point to that part of the record.
If you want, you can take it back.
पहले पहले.
Now is an associate professor, my lord, I Silchar. And he is an expert in the northeastern region, the field of seismology and earthquake. But he was asked to, when he was nominated to submit at my lord a project. Accordingly, project was submitted and account was opened in the name of the institute. Project was not my lord approved, so no money was spent to that account. Only matter for consultant service, he got some amount which was deposited in the account. Now, my lord,
No,
they
whose
filed an
account?
FIR,
Whose account?
NIT, it is in the name of NIT,
NIT.
NIT, the name. And it is the name of the NIT, everything is there, only petitioner was asked to operate the account. Now, no money was sanctioned from the government, no money was raised, my lord. Only consultancy service, that money was deposited. But they filed an FIR, my lord, and that FIR was ended by the FR. So I take your page 68, my lord. If the FIR, my FR can be seen, minus page 68. Page 96, sorry, 96.
Yes.
Now I take my 97, my lord, litigant function, legal investigation. You're watching what is my page 97, third paragraph. Oh, no, my lord, no, yes, my third paragraph. The investigation, the alleged bank account in the case and official records of NIT Silchar was verified. It is found that the alleged bank account in the Axis Bank was opened in the name of NIT. There was a question this. The name of NIT Silchar officially, not in the name of the alleged accused person since January 2024, 14, for the purpose of a government project of NIT. But no any government project as well as government fund was sanctioned, but it was utilized by the faculty for consultancy work from various sources for the benefit of the institute, the NIT, after proper endorsement and authorization by the authority of NIT. In investigation, it is also said that the authority of NIT well concerned with the suspected bank account because the welcome letter from the bank was received by the authority of NIT. After opening a bank account, bank issued a welcome letter to NIT. Checkbook of the account is also received and handed over to the faculty, elite, and account branch of NIT. Due to transfer and retirement of several officers of NIT for which they failed to maintain the said account properly. Finally, the elite person audited the said bank account in the question from opening to the closing by any authorized charter account. The share money, including tax, was deposited to SBI account of SIC to code number so and so, check number so and so. The investigation, they found no any government fund misappropriated by the LD account accused, for which down he was granted anticipated bail by the Honorable Session Judge. Then, my lord, your lordship will find the inquiry, he was appreciated and his suspension was revoked, and he is continuing his job in IT. Since the investigation of the case, it's found that the evidence is insufficient. So, my lord, that it was submitted. Subsequently, my lord, it was not accepted because somebody filed a complaint instead of that was stated by the Honorable Court. Now, my lord, after that, your lordship will kindly come to my lord page 51. So called the charge sheet was, my lord, departmental proceedings. That is state, that is now, my lord, so a criminal part is concerned. Now, page 51, your lordship will find. It's so called
So
notice.
we'll have to issue notice here. Who's for the respondent?
Yes, it's for-
What
only
is the
thing, my
stage
lord,
of the
they-
departmental
Now,
proceeding?
what they have, now they have proposed to impose compulsory punishment.
Punishment has not been
Compulsory punishment or retirement?
Sorry.
As punishment.
Yes,
Cons-
punishment.
Compulsory
It
retirement.
has not been imposed and accordingly it has been referred to the
The
BOG for,
proposed.
yes. It has been referred to the BOG for final decision. At this stage, lordship, this petition is premature.
No.
Action has been taken. If the action has been taken, then the petitioner has this scope of preferring appeal against the order of the any sort of major punishment of the minor.
My lord. My lord, your lordship, kindly see, I just take your lordship to, yeah, my lord, NIC.
But
page-
you're not challenging the departmental proceedings.
Yes,
You are.
yes.
The prayer
Because they have
doesn't say,
reopened after
It
four,
is not there in the
your
after
prayer,
7 years, my lord.
your prayer doesn't
Yes.
reflect it.
Yes.
Your prayer is only for restraining or
Exactly.
setting aside. Okay, setting aside the departmental proceedings. Okay.
Yes, it is there. Now, kindly see page 82, my lord.
Oh.
They have, my lord, they have issued so-called notice, I filed a reply. Reply was not found sufficient, inquiry was appointed, inquiry report was filed on my lord, 1/2/18, page 68. The inquiry report. And now, after 7 years, they are reopening it, my lord. 1/2/18, page 68 to 79. The lordship will find that the influencer submitted a report.
But whether they will impose punishment or not, where is that? Where
Yes,
is that
Your Lord's kindly see,
notice show cause?
yes, your
Where
kindly
is
see
that notice issued?
notice issue, but now page 1 to 18, page 68, the inquiry report. Thereafter, they sent it to the Central Commission of Vigilance.
Ah.
They said, no, you cannot do it because first stage, first stage is advice. You have not taken to second stage advice, it cannot be granted. Similarly, it was sent to Central Ministry of Environment, that is earthquake. Then
Not-
that was also not accepted.
Now what is the state?
Now page 2116, 2126,
Page number?
page number 85.
'85.
Yes. This is the present order. 2116 and inquiry report is 1 to 18. 18, my lord.
So you have submitted.
Yes. Response also you have submitted, my lord.
Now what is the stage after that?
It is pending. I have submitted reply. It is now pending. They are now proposing to impose punishment. And you must kindly see page 68. What they have inquiry report is submitted one day after 7 years. Now they have not. Kindly have a look to page 68. My lord. Again. 68 minus 60. 79, it comes to page 79. 68 starts, 79 last page. Kindly see inquiry report is 1 to 18 and they have issued on 7/11/24 after 7 years. All the date has been changed, now it is issued. And it is reflected in the imperial order on page 85. And circular is very important matter, page 82. So this is required.
Let us issue notice.
The meantime, my lord, because otherwise they can do anything.
Heard Mr. H.R. Chaudhary, then assisted by Mr. H.R. Mr. S.P. Chaudhary for all
Chaudhary together, my lord.
the respondents. Says okay, Mr. Copy is furnished. The petitioner is presently serving as professor,
Associate professor
associate professor
that
in the Department of Civil Engineering, NIT, Silchar. Pursuant to allegations made, departmental proceedings have been initiated against the petitioner, and inquiry report have been submitted, whereby the inquiry officer found the petitioner guilty in respect of all the charges made, all the charges level. Stop. The matter is presently before the departmental disciplinary authority, who has issued a notice to the petitioner seeking reply in respect of the proposed punishment to be imposed. So, it is at this stage that the writ petitioner is before this court. Then Mr. Chaudhary, senior counsel, has submitted that the initial FIR which was lodged against the petitioner resulted in a final report. That part, the charge sheet, the departmental proceedings were initiated in which year?
and that was 17, 7/7/17,
7/7/17, and the inquiry report
1 to 18,
was submitted on
1 to 18.
1 to 18. Stop. However, the departmental authorities have now, where is the notice issued?
Notice is no notice, nothing done.
No, where that
Oh, that one.
that after receipt of the furnishing of the inquiry report,
Yes. 85.
this notice was issued by the
85, page
director.
85.
Director is disciplinary authority.
Yes.
Yes, sir.
The disciplinary authority, namely the director NIT, has issued the notice only on 1/2026. So, counsel for the senior counsel for the petition and therefore submits that immediately conclusion of the proceeding is caused hardship and and without any rhyme or reason, the respondent authority sitting over the inquiry report and have now initiated it. Now have proceeded to punishment by notice dated 2/1/2026. Where is the CVC?
Yes. And
Letter
this is
of
that
notification?
page 82. So this since the commission had not met. Second paragraph, my lord, last line.
The CVC by communication dated 22/10/2021 has declined to offer its comments on the quantum of penalty to be imposed on the officer. Since the commission did not tender its first stage advice, and consequently tendering of comments of the second stage advice by the commission does not arise.
So page 83, my lord, it was sent to ministry, minister also sent to
Page number
83, next page.
83. The
Clause
comments
three, my
of
lord.
from the ministry also
Has to follow the strictly the advice of CBC. Clause 3, my lord.
Ministry also declined, Ministry of Higher Education, Government of India, also declined to offer any comments and directed the NIT to follow the advice of CBC. So, the Learned Senior Council therefore submits that the undue delay in accepting actions of the
Sorry,
inquiry officer
1 to 18.
I use arbitrary, as there is no reason at this belated stage to reopen the inquiry proceeding against the petitioner. Stop. The fact that the inquiry report was before the disciplinary authority was not accepted, and no orders were passed thereon, and no consequential orders were passed thereon, and then the CDC read with the communication received from CDC and the Ministry of Higher Education. It is not open to the department now to proceed against the petitioner by imposition of major penalty. This belated state, that too, contrary to the advice given by CBC and Higher Education Government of India. Such circumstances, present rate petition filed by Mr. S.P. Chaudhary and the CBC on the other end submits that the petition is premature as on date, no other penalty have been passed. He therefore submits that since the department has not proceeded to pass any order, no effective orders can be passed in the present rate petition. Mr. H.R. Chaudhary, Senior Counsel, however, submits that since the notice of the petition meeting major penalty, there is every possibility the penalty termination or compulsory impairment. The third becomes submiss. The third becomes submiss. That will require some consideration. Therefore, the respondents are permitted to complete their instructions and provide necessary affidavit. Matter be listed again on 15th of May. then let them get their instructions.
Till then, my lord, because anytime they may, within 15 days.
That will be, that
Follow for the internet of
also.
justice, my lord. Pendency of it all for the materials
That
of
can
the
be
court.
challenged.
Because you see, if they pass an order, you have every opportunity to challenge it.
Always there, my lord.
But if we
Again, it will be
if we-
multiplicity of suits, my lord. Again, you have become challenging that model. At least, my lord, till then, they, you'll also kindly see the
Since-
whole
since-
thing.
the very proceedings, departmental proceedings have been challenged. The next final order be passed by the respondents. Till the next date.
Then lordship be taken in the first week of May. Lord. Then
First week of May, not postponed. First week of May,
After fourth any day, my lord.
after 4th, 5th,
Let us see what happens.
Yes.
so you may see what happens, but for us, whatever happens, happens.
Exactly. 6th of May.
4th or 5th has no difference for us, except for the fact that
It is for him. my
Oh, no, it is not also not for
Uh,
me.
except for the fact that you will not be available in court.
lord. No.
6th of May. Lord.
6th, we are having it on 15th. We can prepone it by 1 or 2 days, but makes no difference. 15th.
All right.
What did the coordinate bench say?
What did they say for something while the last week? That order was put to page 94. At page 85, the Supreme Court order starts. And the Honorable Supreme Court order starts, madam. The 11th portion is at page 94, para 80. Page 9. Please set aside the judgment of the division bench of the High Court and restore that of the learned civil bench. The appellant shall be entitled to pay revision as on 31/3/2016 and their pay for the month of March 2016 defined in the revised pay, and such revised pay shall be reckoned for computing the pay. So
Yeah. The lordship had on the last 6/5/2026, where we had filed a review against this order passed by the sixth court. Review has been dismissed now. So I've advised my clients to pass some consequential order which covers not only the case but other similarly significant cases. So if the lordship had this matter on 6/5/2026, along with that petition, perhaps some order will be passed by. Review has been
Third counsel for parties. once again, that in terms of the pay undertaken by the as per the recommendation of pay commission, as per the revision of pay in 2010, 2017. Pension which was drawn by the petition was to be revised in terms of PACB revision of pay 2017. So the rule 4A, small a, said last pay drawn, revised, without which the pension cannot be revised. So, allowed by coordinate bench. So, there was subsequently prepared by the bench. By the apex court and the subsequent thereto, review petition was also filed, which also came to us. And under counsel for the submits that this particular case of the present petitioner is also there. Mr. K.P. Pathak, standing counsel, APTCL, submits that a similar matter has been fixed on 6/5. 6/5. So submits that matter should also be listed along with WPC number 735 of 2026, which has been fixed on 6/5. And that he is permitted to complete instruction. This matter again on 6/5. MS serve extra copies. 6/5.
Taxation in the month of April 2025, my lord. Also, on 18th of March 2026, before giving the salary on date, the provisional pay was issued by the was uploaded in the portal and portal by the respondent one. And here the provisional pay slip was issued for any rectification of planning. So it's rectified and clarified by the petitioner. Then we have sent mail to the department, to the officers to rectify the things that is, we have availed the LFC, that is leave to cancellation in the month April 2025, but they have deducted, this one deducted the entire LFC and the TDS in the single month, March 2026, without affording an opportunity, because we have given loads of mail. Now, annexure 4, my lord, that's page number 40, 43, 42. And as a result, my lord, what happened? The EMI is loaned and you were dishonored and which resulted in adverse reporting in civil and CICs.
After that, my lord, another thing is that they have also hold the bank's account. Additional, my lord. With hold the bank account. And for the remaining amount, they have put the hold of, at the entire salary has every 25th day of the month, my lord, the salary used to get deducted, but this for this April month they will not get. March they have deducted the entire salary. They could have deducted.
What is your prayer now?
Prayer- so, my lord, the account.
Huh? They have
Freeze the
frozen
account.
they have freeze the account.
Yes, they before the account.
This is your salary
It's
account.
direct. Yes, my lord.
What is the amount outstanding according to the bank?
It was only 39,000 now.
39,000. What is your salary
Like 16,000
per month?
plus. Yes.
So they are required, they are entitled to 39,000.
Right. Another, after deducting the TPS for the financial year, as well as my demands is that, my lord, they have deducted the LFC that is available in 2025, April 2025. They could have deducted in every month from May 2025 or June 2025 in installment basis, but they have deducted the entire amount of LFC that has been availed, the interest for the LFC in a single month, that is in the month of March 2026, which is arbitrary, my lord. Deducted is okay, my lord, but the entire amount for the interest for the LFC that is availed in 2025, they could have deducted in every month. It could not even meet the day-to-day expenses also. My lord. Rectification, provisional PSC to rectification, and we have given the clarification also. They, instead of giving any response to the mail, they simply deducted the entire salary as well as withhold the account, bank's account. Here is the
Right,
rest of
heard
the
letter
fields.
counsel for election office. Some respondents by speed post 1 week from today. Commissioner's grievance is that for deduction of the amount towards leave fare concession NFC and TDS, tax deductible source. The state bank authority that besides deducting the entire amount, has freezed the salary account of the petitioner. Stop. The petitioner is an employee under the State Bank of India, and by virtue of the and as a consequence of the SBI freezing the salary account, the petitioner is unable to operate the same and carry on his day-to-day activities. So, when was the order or passed? By which order? Or is there any specific order passed?
Provisional letter, that is page 35, the provisional slip was given. After that, on 25th, page number 5, the page, that is in the column March, that is 0. On 25th of March.
So is there any information that it has been freezed?
No, my lord. On
Nothing.
25th, the salary was deducted and it was on zero.
Huh?
Page number 36, my lord.
36.
35 is the provisional pay slip.
36
The column March, my lord, the next
March.
section. It's actually zero.
What does it, what is the effect of this?
But, they have deducted the entire salary. That is the indication. Showing nothing has been uploaded, my lord.
According to the petitioner in the bank statement which is available for the account of the petitioner Kumar for the month of March, there is no amount shown in the account of the petitioner. So it is suspected that the entire salary has been adjusted in respect of the TDS and the LFC by the bank. And petitioner is unable to operate the bank account. As a consequence thereof, he is apprehended. He apprehends that the account has been freezed by the bank. Considering the submissions made. Steps on the respondent by speed post within 1 week. Matter immediately after the no. 27? Huh? Or 24th? 27th of April.
I don't there for they have to freeze the account, my lord, bank account.
So we, without instructions, what, we have no information here as to what is the status. Prayer for interim to be considered on the next date of listing.
I reply.
For not being provisionalized as per the order dated 13/12/2025.
They are not provincialized.
Not been provisionalized. Accordingly, the municipal board has resent their names to the director of the municipal board.
Again,
Again, has been sent on 20/12/2025.
you're still serving.
Yes, sir. They will be serving in its regular session.
Heard. The petitioners are presently serving against regular sanction post under the Dick Way municipal board. Petitioner 1, serving as tax collector. Petitioner number 2, Chowkidar. Petitioner number 3, the bill writer. Petitioner number 4, 5 is the engineer. 7 is serving for number 8. Driver and petitioner number 9. Those who they are entitled to be provincialized under the Assam Municipal Employees within bracket Provincialization Act 2015. Over the names employees. Their names were not provincialized, or to other similarly situated person. Subsequently, we submitted the names of the writ petition. On which date?
20/12/2025.
2012-2025. So thereafter, nation has provincialized under the so and so act. as has been done in the case of the other respondents. Whether it's direction or order, considering the submissions made.
And then 4.
Huh? 1, 2, and 4. Therefore, no
Urban
decision.
different. Pending counsel is there. A,
Huh?
if one is appearing for you.
You're recording your name. 1, 2, and 4. Therefore, notice is the way the extra copy steps on this one. 3 by registered post, by speaker post. Stuff the return will be. Get instructions here. Mr. HM, Mr. I Botaku for
I'm for
public health,
PhD, public.
hearing correspondence number 2. Why Panchayat is there?
He went there on deputy.
Deputy man, he heard from Panchayat department.
Mr. he goes for number 1, 4, 5.
Their instruction may also call for.
Mr. R.K. Talukdar for respondent number 6. Anyone for finance? I A Botaku for respondent. Additionally, we believe that although the petitions were animated on 1/3/2023, suspension has not been finalized, not even been issued. The respondents complete their instructions and file necessary affidavit. This again after returnable date. 15 May.
And the order is 12.
Appointment letters to be found in our headquarters. Yet we are searching for it. Here is in the record in our headquarters. Signature office. Find any record that they have worked for some particular period of time, we will pay for it. So my lord may kindly allow some time to find out the.
The order of the court is passed in 2018. We are in the year 2026. 8 years. You have to explain why for 8 years this order has not been complied with. Or you have to explain why we should not draw up contempt proceedings against your clients, namely respondent number 1, 2, and 3, and send them to prison for violating, 1, for violating the order of the court. What kind of instructions is this that if you find, you will inform? You are bound to carry out this order. Who has instructed you?
I'm senior seller.
No, but who has instructed you? Is it your senior or is it the clients? Who have instructed you? Have you read the order? Page number 8. This is an order where you are directed to pay or if they're found to be working, how can you say that the records are not available here, there? This is an order, carry out, you file a review, go in appeal. But you can't allow this order to sit here for 8 years on the ground that you are still searching for your records. It can't be done like this. We are fixing on 20. If you don't get your instructions, we are drawing up contempt proceedings against the respondent. We are putting you to notice. List on 20. By which date the counsel for the respondent will apprise the court on the steps taken to comply with the directions of the court dated so and so, passed in WPC number so and so. So if the instructions as directed are not forthcoming, court will proceed to issue consequential orders if required under the Contempt of Courts Act 1971, read with the Gauhati High Court Contempt of Courts. IA for
Incumbent has in the meantime.
IA 1679 filed by the petitioner is for implement of the opposite party number 2 as a party respondent as it is submitted that presently the opposite party number 2 is presently in the office of Managing Director, Assam State Transport Corporation. Any objections? Since no objections are forthcoming from the respondents, the IA stands allowed as it is submitted that the opposite party number 1 has since demitted office. When did he demit office? Dependency of the contempt petition. Therefore, the opposite party number 2 is to be implemented as a party respondent number 2, the accompanying contempt petition. So, submitted that the directions contained in the order dated so and so, passed in WPC so and so, has not been complied with. It's court of the view that prayer made in the IA should be allowed as the opposite party number 2 being presently managing director of ASTC so and so, required to apprise the court regarding the compliance of the directions of the court's order passed in the order dated so and so, WPC so and so. Accordingly, let opposite party number 2 be arrayed as respondent to contempt case number 661 of 2019. The petitioner will file amended course title within 1 week. IA accordingly stands allowed disposed of the contempt petition is right in view of the IA, passed in the IA so and so. Party number 2 in the IA, namely so and so. There it is, respondent to contempt case number so and so. Then we are fixing it on 29th. Matter be listed on 29th. You first make the changes, then we'll issue.
Nothing. Apply.
Applicant. As per the official note, no ID card has been issued. Steps has been taken in the month of February.
Steps taken in
February.
of 26.
Yes, madam.
You want to take fresh steps or we wait for
We can.
uh,
And
office note
it's
dated?
regarding CRPF and not. She has the instruction.
Till now I have the instruction to appear for 1, and for them I have already prepared the affidavit and sent it for vetting, but for respondent number, notice this served lordship, it's a conflict.
Office note dated 6/4/26 reflects ID card. A service on respondent to is awaited. Counsel for the petitioner submits that he would like to take fresh steps in the matter. Prayer allowed, petitioner will take fresh steps by speed post. Respondent within 2 weeks from today. Yes. Petitioner done its ABC has the entered appearance on behalf of respondent one has filed an affidavit.
No, I'm supposed to file.
And she submits that she would like to file an affidavit. Placed again after 4 weeks.
Okay.
File it
But
first, you take your steps, make a mention.
Much of it.
Later. But in terms of the last order dated 2026, we have filed our affidavit of question yesterday. The same is not on record.
See copies. You want to file any reply?
Because in the reply, my lord, they have brought one.
We don't know, it is not here.
Not yet, yes. That is
Mr.
correct.
S. K. Ghosh appears for the
Maybe that
petitioner.
is-
Mr. A. Barua, and counsel appearing for the accountant general submits that they have filed an affidavit. The opposition yesterday.
Yesterday.
Vera. State affidavit is not connected to the case record. Registry to trace out the affidavit stated to be filed. They connected to the case record, and is the matter on when?
My lord, on 23.
24. Mr. A. Chakraborty for
So number 6.
respondent 6. Is accordingly. Able.
Respondent number 6 already appeared also. And regarding respondent number 7 and 8, neither the ID card nor any answer.
You want to take fresh steps?
Can wait because the postal consignment report indicates that
But pursuant to issuance of notice, steps have been taken on respondents. Stop. As per Office Note 24/2026, steps have been taken on council. The respondent 6 is represented by Mr. Barua, appearing by his power, the above respondent 6. So far as respondent 7 and 8, although any cards are not received, registry's note indicates that as per the postal journal and postal consignment report, the since have been shown to be delivered to the respective addresses. Stop accordingly. Taking into account the registry, it is noted that the services on respondent 7 and 8 are deemed complete. Let this matter be listed again on after 3 weeks. And the respondents, for appearance of respondents 6 and 7 and 8, respondent number 6 in the meantime can also file their affidavit. Yes.
Since the matter relates to suspension of the petitioner as well as the proceeding which has been issued against him. Kindly just take your also to the relevant documents. Kindly turn to page 36 for a moment.
36.
36. Annexure C.
It's an email.
Yes, sir. This is dated 12th of December 2025, whereby I have been informed The next page, that is the enclosure of the email, page 37. Notice for hearing in connection with the complaint received on financial impropriety. Now, you are hereby informed that the fact-finding committee constituted by notification number so and so will conduct a hearing in connection with file against you. You are requested to appear before the committee as per the schedule given below. And I was told to appear on 17th of December. I went and appeared with them. And what they have done is, if you turn to page 40 now, this is the statement which they have recorded before the fact-finding committee. I'm reading paragraph 1. The committee read out 2 complaints. Read out, Your Lordship. Filed by Shri So-and-so on 28/11/2025 and Kali Kishore Das on 27/11/2025, along with supporting documents attached by the complainant with their complaint, like WhatsApp communication, record of bank statements in connection with the financial transaction certified by the bank. Committee also asked whether I know the complainants and want to know my views. Response: I personally know the complainants being in the university and strongly deny and disagree all the allegations made by the complainants. Now, immediately thereafter, Your Lordships, by way of the next page, page 42, they have placed me on under suspension on 18th of December. This fact-finding was held on 17th of December. On 18th of December, they have put me under suspension, and the suspension period was to get over on 18th of March. One day before that, on 17th of March, they have circulated an email by which the executive council meeting has been held. Now, one of the grounds that I'm taking for Your Lordships is that this itself is impermissible in law, because the executive council meeting can be held only either physically or at least through a video conference. What they have done in my case is that they have circulated an email, and through that they have, number one, extended my suspension, and number two, they have issued the memorandum of charges against me. If I may just take Your Lordships to
You are referring to this executive meeting held on 18 December.
18/3, Your Lordship. I'm taking Your Lordship to that. Your Lordship, can you turn to annexure page number 48. This is again the mail which has been sent to me on 17th of March 2026, Your Lordships. Page 49 is the include charge sheet.
So what is your prayer now?
Lordship, the prayer itself is, now they have taken a ground. The charge sheet is of an incident supposedly, allegedly, which had occurred sometime in the year 2020-21.
But you are entitled to file a reply.
Yes, Your Lordship. And when I have asked for the documents, they have refused to even give me the relevant documents. First, I sent them a mail saying that the allegation which has been made against me is by way of a document which is not even signed. So I said, where is the signed document? At least provide me with that. That also they're not agreeing. Now, just a few days back, on 4th of April, I sent them a mail saying that at least extend the time for me to file my documents. And you also will kindly turn to the last page of the writ petition, page 85. If I may just read the contents of page 85 also, in the middle of the page. Sir, the university has already provided you all the relevant documents, and a detailed response of your earlier mail in this regard has already been made by email dated 30/3/2026. You are hereby asked to respond latest by 10th of April 2026 to be received by this office. No further extension or request in this regard shall be considered. Please take note that in the absence of your response by 10th April 2026 in this office, the matter shall be treated as ex parte. My only prayer at this moment, and this document has come to me only yesterday, Your Lordships. Only yesterday I have received this document, and my humble prayer for Your Lordship right now is that, number one, the suspension order which has been extended is without any reasons. I will take Your Lordship to that. What is that annexure?
So, but there will need the views of the respondent.
Let them take the instruction process. Let them not force me to file my reply before 10th of, if Your Lordship will at least just grant
It's
me
not a question of, it's a choice, whether you want to file it or you don't want to file it.
Lordship, that will prejudice me to a great effect if
Why?
they do not even give me the signed copy of some particular document. The complaint itself is an unsigned complaint.
Where are your applications?
Lordships, I will just one of the applications is at page 82.
82.
No, Your Honor. I sorry. Just one. 79, Your Honor. Yes, Your Honor. One of the pages is page number 79.
What happened to this?
Lordship, they responded to it on 18th, on the next day. They have responded to it on 30th of March, telling me that no, your Lordship can turn to page 82. That is the reply to this particular mail. And they said that in response to your email dated 27 March 2026, the undersigned would like to state that all the relevant documents of the basis of which charges were drawn has already been provided to you along with the charge sheet. Now, if I may just take your Lordship to the page where what they have provided is at page 55, Your Lordship. 56. 55 is the typed copy. 55A is the typed copy. And 56 is the original document, Your Lordship. This is what they have provided to me. This is not even a signed document. How am I supposed to know who has filed this complaint against me?
Where is the charge sheet?
Lordship, the charge sheet starts at page 48, Your Lordship. I'm grateful to my friend. Page 48 is, it starts at page 49. 48 is the email by which we have been given this document. Now, Lordship, the charge which they have put against me is that I had taken some amount of money from this particular
No,
gentleman.
these list of documents at 55.
Yes, Your Lordship.
Have they not been furnished to you?
Copy of the first one itself, Your Lordship. That is what I'm saying, that this is a complaint which is an unsigned complaint. You are saying that this gentleman, someone called
No,
Kali
but
Kishore
if-
Das.
The question is whether these documents at Annexure 3
Yes,
has it been furnished to you or not?
these have been furnished, but I am saying that these are the first and the first one. And the Annexure 3 first document itself is not a document which can be relied
You
upon
take
at
your
all.
defense. You are entitled to take a defense on that.
Yes, I certainly would like
But
to take
supposing
a defense, but they're
they-
not even extending the time limit. Lordship, the problem was
Huh.
that I have tried to ask them that at least give me a signed copy of this complaint.
Why
How do I know?
No. We don't know whether they have a signed copy or they don't have a signed copy. You are entitled to take your defense on that.
Yes,
If
Your
you
Lordship.
think that it is not a signed copy and proceedings cannot have been proceeded, that's a different issue. That is your call.
Correct.
But if they have not furnished to you these 7-8 documents which are reflected,
I had asked for several other documents, Lordship, by way of my email.
other
which I have just-
documents, they are not technically duty bound to furnish because they are not relying upon the case. They are
They
not
are saying
building
that-
up their case.
Lordship,
They are building up their case only on Annexure 3.
that is correct, Your Lordship. But then the problem which one arises, Lordship, that how do I know whether this complaint has actually been filed by this particular gentleman?
That
There
is
are
for
two-
you.
there are two
Therefore, the
documents,
inquiry. Therefore, the inquiry.
Lordships. They are not. The
If-
charges
if-
has already been issued against me, Your
No,
Lordship.
maybe, but it is for you to take a defense that is not filed by or it is not a inquiry to be proceeded, whatever defense you want to take. But if under directions of the court, if they have to give an order, then we'll need materials to say that there is no complaint in the name which is
But
in
see,
existence.
At this stage, I'm not saying that Your Lordship should
Ah.
stay, should stay the discipline proceeding.
We
as
can
long
give
as
you an
some-
extension if you want for
If-
another.
Lordships, if that can also be done by
yes.
let my Lordship get his instruction on the matter.
PU season, give an extension for 2 weeks. No problem. He's very accommodating.
I'm grateful to my Lordship.
Give an extension for another what? How much time you require?
Just post being for at least 24, 25th, any day.
What is the date? 10th.
10. Yes.
Then we'll give you another 15 days.
Lordships.
That makes it 25.
20.
Right. Heard. Yes, R.S. Chaudhary, the Council Commissioner, Mr. L. Council appearing for the university. All the respondents. MS Jagrival appears for the UGC. 5. The petitioner is agreed by notice dated 7th of April 2026, which is served on the petitioner by way of an email, calling upon the petitioner to furnish his report by 10th of April 2026, failing which the matter will proceed ex parte. So the petitioner, the respondent authorities have initiated environmental proceedings on the petitioner by issuance of a show cause notice dated
7. Annex to G.
page number
8. It starts at 40, 12 starts from the
dated 17/3/2026. Certain documents were sought for by the petitioner, and according to the petitioner, the document sought for entirely has not been furnished. As a consequence thereof, petitioner is unable to file his statement of defense. So, Mr. Kial on the other end submits that the documents which are required, which are endorsed to the show cause, have already been furnished. So, the counsel for the petitioner submits that the first document, which is available at Annexure 3 to the namely the complaint lodged against the writ petitioner, is the copies which are furnished are not signed copies. So, they submitted. If they're not signed copies, then the very process of initiation of the department proceeding is contrary to law. That apart, the other documents which are furnished, which are sought for, have not been furnished. During the course of the hearing, on queries made by the court, the learned counsel for the petitioner clearly submitted that, except the document at serial number 1 in Annexure 3, show cause notice, rest of the documents are furnished. Insofar as the document at serial number 1 is concerned, a signed copy is not furnished. So, that apart, date of filing response has been fixed on 10th, and unless the documents are furnished, she would not be able to, petitioner would not be able to file the written statement of defense. Considering the submissions made, this court is of the view that the respondents should furnish all the documents, including the document at serial number 1, mentioned in the enclosed to the show cause notice of the writ petitioner. Thereafter, the time be extended for filing the written statement of defense by the writ petitioner. Stop accordingly. Considering the limited prayer made, writ petition stands disposed of at this stage, directing the respondent university to furnish a signed copy within.
All the documents have been supplied to you.
All right, furnish another signed copy within 2 working days.
Yes.
Working days, the writ petitioner, and thereafter, the petitioner will file the written statement of defense within a further period of 15 days thereafter. So, accordingly, the petitioner, the respondent will furnish the documents by 10. Today is 7.
11th.
By 11. 11th is a Saturday.
Saturday on basically.
By
All the
11.
officers are on vacation duty. They will return on 10.
So 11. Or you wanted to go next?
No, 11.
11. By 11th of April, as submitted by the studying council of the university. Thereafter, the petitioner will file the written statement of defense within a further period of 15 days, not later than 27th of April. But the university will thereafter proceed in the matter as per procedure prescribed. Writ petition accordingly stands closed, disposed of. That's all.
This
not be a bar for me to come back for my challenging my suspension. If
Since the
advised-
writ petition has been disposed of without entering into the merits of the correctness of the proceeding brought. But for the writ petitioner to approach this court
Sorry.
if so advised, and if the grievances
That's the work to have done the verification.
Hmm, hmm.
It's the office not others respondent ought to have filed their affidavit.
Yes, respondents.
And I'm appearing for the private respondent number 3, 5 and 6. Kindly come to page 28 of the petition. There is not.
No, we are not hearing matters today. Let's be clear, because it's the last day we have to sign the orders. From tomorrow,
True, man.
everything is closed. So unless there are very urgent matters which needs to be heard today itself, civil liberties, throwing you out of the house, rest of the matters we'll have to.
One thing, my lord, what's the matter any other day, my lord, being the maintenance of it.
Have you filed your objections?
Objection, my lord.
Affidavits?
No, my lord, not recorded because earlier round of litigation, my lord.
The respondents may file their counter affidavits if so advised in the meantime. Matter be listed for admission on 6th of May.
And we will be deferred the gap problem.
Question of maintainability, which is urged by the respondents, is left open to be decided at the time of admission.
Madam, there is another player. Same petitioner has filed on other occasion WPC 7062 of PDPC. The records of this case may be tagged with manual evidence. I have been
Do it on the next day. Once you urge the matter and you tell us that why the records are necessary. Oh, it is already here as a
It's already. And it's okay.
list on 6.
Seeking appointment, my lord.
Appointments. You are agreeable.
Lordship, item number 18 and 19, the instruction was listed in this.
Then all these matters are between the same contractors.
Same
contract.
Different sets.
Different sets of contracts. So is there any matter where there is no disagreement?
The earlier, as per instruction, Lordship, earlier they approached in other forums, but that has been complied with.
Tell us what you want to do. 17 and 18 you have received instructions.
17 and 18.
Then 19 and
another
20,
Same would actually cover it. Same instructions. would
same
cover
instructions will
because
cover.
Same contract.
All right, 17, 20, is it?
17, 18, 19,
20, 17 to 20. The respondents submit that they received instructions yesterday, like to file their objections. This time is prayed for. Prayer made is allowed. Mr. B. Pathak appears for the petitioner. Mr. Lokor appears for the railways. Sorry, Ministry of Road Transport. MS Bhattacharya appears for Mizoram. Government of Mizoram. Sharma for National Highway. Huh? For National Highway. Okay. 18 and 19, Mr. Lokor appears. Who appears in 18, 19?
18 and 19 I may pay.
Lokor. And 20,
17
21.
and 20, Mr. B. Chakraborty was there. So it says
17 and 20, message Sharma appears. Baki state or Mizoram. Bhattacharya, you appear for all in all the matters. Stakeholder.
Kindly look at the last order.
Yes, who's for health department. Health Department. By the earlier order dated 11/3, yes, it's in Health Department. No, sorry, this is Forest
For
Department.
your lordship. Just see one instruction, lordship.
Ah,
Yeah, places. Some more time, your lordship. The process is under process, your lordship.
this no due certificate is not being sent earlier.
Thereafter, we made a referral for the board, but the very said that yes, the JNRs. For that, we have to get the certificate.
No, see your instructions. Requested to furnish certificates relating to earlier no payment.
No
claim.
payment and no claim from other sources.
Then
That's
when you send up a proposal, you have to give the no due, no claim certificate.
that proposal was called that was not submitted. That's why the fresh transfer.
Matter of pending since 2008.
Have you submitted no claim certificate?
Yes, earlier we have submitted.
Is it available in the writ petition? The Council for the Forest submits that the proposal for medical reimbursement of the writ petitioner has been returned back to the office of the Principal Chief Conservator of Forest and HUFF Assam to furnish certificates relating to no payment and no claim from other sources. So the Mr. Gogoi, Council for the Forest Departments, submits that the proposal is required to be submitted afresh after along with the certificates for no claim or no claim payment from other sources. Stop. Counsel for the petitioner has submits that already these certificates were furnished to the department. Let this exercise be completed expeditiously, and by next date, the petitioner should apprise the court as to the status of the proposal, as to whether this proposal has been resubmitted along with all necessary documents. At least on 27th of April.
Okay. Actually, the sanction was accorded in the name of the petitioner number 2, the minor lordship. So lordship, some difficulty arose, lordship. Yesterday, lordship, again, lordship, the sanction has been accorded in the name of the grandmother. Lordship, this will take some time, lordship. Let this matter be taken up.
These are cases, classic cases of non-application of mine at the cost of public expenditure, and no explanation why these expenses should not be recovered from the hearing officers from their salaries. You issue a certificate in the name of a minor, knowing fully well that the person is a minor.
Because there was an annexure annexed with the petition lordship. Anyway, now sanction
Where is the sanction order?
lordship.
Who is respondent 9?
Respondent nine, the mother,
Mother.
you're also saying her right now has married another person. The minor children are under the guardianship of their grandmother.
Submitted by the Standing Council Health, Mr. Manu, that the earlier sanction order granted to of the petitioner number 2 had to be reissue as both petitioner 1 and 2 are minors. And the sanction by order dated 7/4/2026 has now been issued, has been accorded in favor of Srimati Kaushalya Basfor, the grandmother of the petitioners 1 and 2 and the natural guardian of petitioner 1 and 2. Stop. Sanction is accorded for provisional compassionate family pension equal to 100% of the last basic pay plus other allowances as admissible in favor of Kaushalya Basfor, the legal or natural guardian of the petitioners. Stop. The earlier order of sanction was cancelled. Stop. This order is issued on 7/4/2026. Counsel for the respondent submits that this particular the payments are likely to be received within a period of how much time? 3 weeks time. Raised this matter on 6th of May.
CP of that.
Last quarter, 13th of March.
Instruction were received but not detailed instruction. For the time. First,
What is the prayer for interim?
My interim, my lord, that implement order 2/26, my lord, is not to be given effect, my lord.
Where is 2/26? Page number?
Page 74. It's based of 1989-91, my lord, but here only published 88-90 only, my lord. My retirement is 31st of May, my lord, this year.
It has already been finalized.
But they have finalized, therefore we are before this court, my lord.
Oh.
They finalized, you know, by depriving our batch, my lord. I am the batch of 89-91, my lord. So my due retirement is not 31st May. This, my lord. So my lord, learned, for
You have been shown to be junior.
no, not junior, my lord. I'm also equally placed person. I'm also eligible for the DCF, the Deputy Commissioner Forest, my lord. But what happened, my lord, they have published, my lord, initially 2024, my lord, including, my lord, all the 88 to 91 batch they have published, when my name is also in the gradation list. But here, surprisingly, my lord, on 2/26, only, my lord, they have considered the batch of
88,
90, not 89-91. Why, my lord? No explanation, my lord. And lordship will find, my lord, very surprising, my lord. Kindly look, my lord, page 80, annexure 14, my lord. Annexure 14, my lord. That is on
So this is a gradation list for
together all, just
Huh?
including, my lord, 80,
of Deputy
yes.
Conservator of Forest.
Yes, all. But without modification or cancelling this, you know, why they can separated us and only publish for that batch only? Why not to us, you know? Only this April and May remaining, my service period.
No, is it your case that your name should have been in 88-90 batch? No.
No.
Your case is that is the
89,
finalization of gradation list for 89-91
91 batch.
ought to have been done.
Yes, my lord.
Yes. Mr. Gogoi,
Lordship, even though this petitioner already approached the court earlier, Lordship, the petition file contempt was even filed. Therefore, speaking order was passed, whereby it says that the gradation list which is impugned is per the order of this honorable court, Lordship. Yeah, please speaking order, Lordship.
What I'm trying to understand from your submission, Mr. Degar,
My lord,
is that your claim is only with 8991.
mine 8991.
So how does finalization of 8890 affect you?
My lord, since my lord, those employees, my lord, 8890 is concerned, my lord, I am also eligible in the earlier 2024 graduation list for the this post. Final graduation list published in 2024. Suddenly, I am waiting for the receive. I am also eligible candidate, my lord, employee, my lord. So, my lord, without considering
Where is
that,
the final gradation list?
Yes,
Oh, where is the draft?
yes, draft also been fine. Initial draft, my lord, at page 75. Page 75, it is 13th January 2023. And lordship will file 76, my number is 58. Orders.
58.
Yes, my lord. 58. Next, my lord, this is a draft. Then final gradation list lordship will file in HR 14, page 80. My number is 59. At page 85. This is final gradation list, my lord. 59, my name. The final gradation list, my lord. Suddenly, my lord, this Indian gradation list was, my lord, only considering the base of 1988 and 90. Why not 89, 19 no explanation, my lord?
Third counsel for parties, the petitioner before this court is agreed by non-finalization of the gradation list for the batches of 89 and 90, 91,
91.
to which the writ petitioner belongs. Petitioner is presently serving as Deputy Conservator of Forests. Although in the draft gradation list, names of the petitioner appeared, however, by order dated 2/26, page
Yes, my
number,
lord. 2 to 26, page 74.
order dated so and so, 2026, gradation list has been finalized. Only in respect of 8890 batch. Stop. According to the petitioner, the non-finalization of the gradation list with respect of 89 to 91 batch,
91.
to which the petitioner belongs, will have the effect of depriving the petitioner for his further promotional avenues, as the petitioner is superannuating in.
But I'm TF4, my lord. In Nogao, I'm
When are you retiring?
on 31st of May,
26.
26.
It is demitting office on 31st of, superannuating on 31st of May 2026. Stop. Under such circumstances, the respondents were permitted to obtain required instructions. The instructions have been placed before the court. Submit that the gradation list has been finalized in terms of the directions issued by the court in WPC 6723 for 2013 by order dated 9/4/24. From the instructions furnished, not clear why. It is not discernible that the direction of the court was restricted only towards finalization of the gradation list for the batches of 88 to 90. So, such circumstances, what is the stage of process for promotion?
Promotion is saying, okay. That instruction I don't have. That present.
Under such circumstances, the department will not proceed to undertake steps for promotion to the next higher post of
Deputy Conservator of Forests.
Deputy Conservator of Forests, only on the basis of the final gradation list for the batches of 88 to 90 without finalizing the gradation list for 89 to 1991 batch. The interim order passed will continue to the next date of listing based on 29th of April. Mr. Dr. Tony for PSC. UPSC.
Respondent number 9.
Because consider it, if you think so, you can file an application for striking of your name. Yes. If required. Dr. Tony for EPSC and MSP Sharma for APSC. List on 29th.
If no, not sure.
Hey, well, letter involved for motion on 6/3 lordships. Since actually the state respondent was elected.
Any instructions?
No, Lordship. Time will be.
Mr. R. Sharma for the petitioner, Mr. E. Chakraborty, the respondent. Prayer for further instructions. Further time. It's taken after 3 weeks.
Public. Item number 30, Lordship. What's the instruction you have to receive, Lordship? They have stated that they are busy in election duty, Lordship.
The matter of suspension or review circuit matter 92.
After 4th, Lordship.
You think they
You are suspended.
my lord, actually what happened, the police was arrested me, my lord, on my lord, 20 July 25.
You are serving as what? Gaumura.
Down from my lord, what happened, they are, as per 6/2 of the Assam civil, Assam
Where is the
Civil-
order of suspension?
suspension order is not issued to me, my lord. They are not communicated, my lord. So, my lord, when I went to join DR, my lord, wished to join DR, my lord, they prevented me, my lord. Neither suspension or issue, but there is a communication, my lord. Kindly look into that, my lord. That commissioner has directed to the, my lord, circle officer to investigate the matters, my lord. Annexer, kindly, my lord. Lordship, kindly annexer C, page 40, lordship. They are also awarded, my lord, page 40, my lord, annexer C. By this latest, my lord, pursuant to suspension of Devadole, that communication is not made to be, my lord, suspension. But 6/2 of Assam disciplinary appeals, my lord, is clear. If somebody is, my lord, custody beyond 24 years, 24 hours, then it is deemed to be, my lord, suspended. So, my lord, neither review nor, my lord, succeed, my lord, still to be. The last are direct to the department. Instructions with the what the status of the discipline proceedings.
No, where is that communication?
No communication.
No, you said some director has issued or something like that.
My lord, page 40, my lord, annexer C. 20 July 25, my lord. This letter issued by the Dipmati, my lord, district commissioner, the my lord circle. Made an inquiry.
Heard Mr.
Peter.
T.L. Das, Mr. E. Chakraborty, respondent. Petitioner submits that when serving as a lot Gaon Pradhan, he was suspended. However, no order of suspension was issued. But from the communication issued by the district commissioner, it's come to learn that an inquiry was directed to be conducted by the esteemed commissioner and submitted report. So, thereafter, suspension is issued. The petitioner has not allowed to verbally informed that he will be suspended. There are Mr. Chakraborty, learned CA Government Council,
Respond number 3, 4,
appearing
and 5.
for District Commission.
District Commission along with staff.
And MS Hazarika, appearing for the Revenue Department, submitted instructions are anything. While granting further time to the respondents to complete their instructions and file necessary affidavit, it is directed that the Deputy Commissioner, respondent number 3, was a copy of the suspension order to be served on the petitioner, and in the event the inquiry is conducted as directed, this order dated 007/2025. Steps thereafter taken by the Deputy Commissioner be apprised before the court on the next date only stick. Based on 6th of May. Not. Or will it be too early? 8th of May. 8th of May.
That much, my lord, then whether you or subsequent issue.
All these will come.
One of them. Obliged.
8th of May.
Obliged.
Yes. As per order dated 18/2026, respondent number 11 is submitted. Deputy. It is on record, but direction was also to the Deputy Commissioner to submit. Paragraph 5 of the.
Deputy Commissioner, are you filing any affidavits? MS A. Bora, counsel for the NHN, submits that affidavit has been filed. However, no affidavit has been filed by on behalf of the Deputy Commissioner, in spite of specific direction by the court on 18/2/2026. Mr. A. Chakraborty, Government Advocate, is permitted to another 2 weeks' time to file an affidavit as directed in the earlier order. Mr. S. D. Gauhati appears for the writ petitioner list on 8th of May.
Required some time though. Those 7 witnesses examined at the time of RI custody.
What is the issue here?
The time
What interim order is granted?
there is first ordering for RI custody of 89 days. Will he continue with the RI custody, then he prepare an appeal for the suspension of this order. Instead of given any relief, another punishment is given for deducted rupees 15,000 from his salary. That part is stay. Only one installment.
Pleadings are exchanged. You filed your
Affidavit file.
affidavit file. Heard.
But a record is required.
Issue rule call for records. Is this matter for hearing in the month of June? Interim order passed early will continue until further order. Yes. Pleadings exchanged.
I have filed my affidavit.
You want to file your response?
My lord,
Any
in one
rejoinders to
case
be
I have
filed?
filed, that will cover the next.
Right. Then we'll keep it for hearing.
Yes, yes. I'll circulate a copy of the.
You are filing only one affidavit.
Yes, that will cover.
That will cover
similar-
all the cases.
Yes.
Heard counsel for party, Mr. S. Doctor, hearing for the ENRD.
Yes, ma'am.
Submits that in WPC
3601.
3601. An affidavit has been filed since the facts, since similar issues are, since in the other connected petitions, similar issues are raised. The said affidavit will reflect will be relied upon by the department council. In the other writ petitions also. So under such circumstances, the council appearing for the PNRD is permitted to serve sufficient extra copies. The council for the petitioners in the other writ petitions. So the respective council writ petitioners in the other writ petitions are also permitted to file their rejoinders if they so desire. This is matter again after 4 weeks.
Yeah, because item number 34 and 35, there is an interim order that without leave of this honorable court, they will not proceed with the treatment process.
The interim orders wherever passed continue.
I am, because already they have select list issued and they have appointed also. That is why some urgency is there. Yeah, I will pray for a date, madam. Some posts are still vacant. Right.
14th of May.
All right.
It's complicated. This particular case, 2 petition was filed without noticing the earlier order passed by the Honorable Court. Last order was remanding the matter to take decision. Accordingly, they have cancelled the whole selection process. Earlier, this court has upheld the selection process. That is the only lordship. Against one post, 4 should be selected for interview. Here, lordship, this short. That is why it was remanded back to the authority again to take decision. But already this court has decided the matter and upheld this election. That was not bring to the notice of the honorable authority. That is why they have passed this order cancelling the whole selection process. That 1:4 was not selected. But that was not brought to the court. Because already matter has been decided by this honorable. That was not placed. That is why they have cancelled.
Where is that impugned order?
Doctor will find the impugned order at page 39,
39.
39 and 40, 41.
First, where is the order of the court?
Pass order also find at page 31. Next order, page 36. It was remanded to the authority on the same ground. It was silenced.
No, but you said it was decided. Where is the decision of the court?
Decision court has said that there is no irregularity. Okay, fine. I have paid the entrance result sheet on certificate.
Page number?
35.
35. Yes. And result sheet. Yes. Does not find any reason.
No. Second order, page 36. Remanded to the authority on the same ground. Because earlier order was not placed before the honorable court.
Are you saying that there is a conflict between 35 and 37? 35 has come to a conclusion that there is no need to interfere.
Not really. 36.
As they could not question the selection of 28 in the 7 unreserved posts. Then
Page 37, same ground, that 1:4 ratio has not been followed,
not been followed,
and that is why remanded the matter to the authority to express decision.
right?
And thereafter, look, without going to the earlier order, those will find page 39.
Huh?
Page 39.
39.
Page 39, subject reference WPC number demand, that is the last order. And cancel the entire selection process.
So, but the liberty was granted to go for a fresh selection.
Free selection, but we have selected candidate on the first
No,
selection.
the liberty was granted by the court.
Liberty was granted, but they have said cancel the selection process.
That's what. So unless the earlier selection is cancelled, how will they go for a fresh selection?
We have selected candidate in the initial selection process.
Please come to page 38.
Page 38. Page 38. In view of the above, this petition stands disposed of by providing that respondent shall take a decision in the matter at the earliest and notify the same. It will be open to the respondent either pursue the present selection if the same is permissible as per rule, or to go fresh selection process if so advised. But in this petition, the earlier this order has been passed. Also, will find this order has been passed on 25/9/2024. Earlier order has been passed on 4/4/2023. This order was not placed before single as well. This order has been passed. That already same selection has been challenged on the same count. That 1:4 has not been followed.
That is what we asked you. That is it. Are you submitting that the order at page number 35 is in conflict with page number 38? Is that what you're saying? Both are conflicting.
My submission will say this court has already held that there is no irregularity in the selection process.
Right.
So they cannot take a fresh decision when this court has already decided matter.
But the liberty is granted at 38.
Liberty is granted. Liberty is granted. What liberty also will find? The last order by 25/9/2024, liberty is granted if permissible. But that order was not placed before the court. That is why Lordship in
Which order was not placed?
Lordship will find page 39 again.
Huh?
Page 39 again.
39.
Lordship.
Yes.
Why this order has been passed? Because this order was not placed. The subject WPC number demand. That is last order 1505. Samin Ahmed. Considering this order has been passed.
I have not understood what is right. Which order has been considered?
Last order. That is passed by Justice Suman. That is page 37.
We've seen that 37.
This order was not placed. Earlier order passed by page 31 was not placed before the authority.
Before the authority.
Before the authority, government.
Before the government. And then what order was passed?
They have considering only the last order passed by this court on 25/9/2024, cancelling the selection process after filing contempt petition.
The earlier order will stand merged with the later order.
Last order, in the last order, the earlier order passed by this court was not placed. That is why this order was passed. Otherwise, this court will not say remanding the matter again to the trial authority.
So that's what we are trying to understand your submission. Are you saying that the order at page number 35, this 35 conclusion of a coordinate bench was not brought before the notice at page 37 when this court had passed when a different coordinate bench had passed an order? Is it what you're submitting?
Yes.
If that is your submission, then you should have gone in review.
Not only review, because this order has been passed by this honorable court, and thereafter authority has cancelled the process. And
that is because of some liberty is granted. Whether the cancellation is good or bad, it's a different issue, but the liberty is granted by the court at page 38.
Liberty is granted. But this order was passed.
You are saying that in 35 there is already a conclusion that there is no illegality.
And
right. So therefore, page number 38, while disposing of that liberty ought not to have been granted. That is your submission. That requires a correction by filing a review. You're not preferred any review.
We have not prepared in the review because we have Salinity.
You are now asking us to exercise review jurisdiction while exercising review.
We have Salinity cancellation. Subsequent.
That's all right. The
And because
cancellation
in
order.
subsequent cancellation order, the authority, before the authority, that order was not placed.
All right, we'll examine it.
Only
Mr.
thing is-
S.K. Goswami, London Council Petitioner, and Mr. D. Hazarika for revenue, Mr. A. Chakraborty for the state. Meetings have been exchanged. Matter be listed for hearing.
No, no, admission state was pretty smooth.
Admission, hearing, everything can't be admission here.
May I submit one thing? If Lordship remanded the matter to consider the case afresh,
So
consider
we
the
have to apply our mind. Already you are pointing out some confusion in the court's order. Now you want a third confusion to come.
No. Lordship, same matter. It is same matter.
We know that, but these are corrections which ought to have been done. You would have immediately filed a review petition to say that once the court has already given a finding, there's no occasion to remand it back and rely upon that. That has not been that step has not been taken by you. Instead, you are challenging the order of the department. Say that the interim order had already decided the issue who are the petitioners. So therefore, there was no occasion for the respondents to act upon it.
Take a fresh decision.
The list on 21st May.
In order to continue.
Interim order passed early.
Apply.
Hearings completed, matter be listed for hearing, issue rule, call for records. The month of June,
Amendment of there is an interim order.
interim order